This is Scott Drake. Speaking of justice, you're watching the Legal Broadcast Network. Chris Brown briefly appeared in court yesterday, hours after he was charged with 2 felonies stemming from what a police detective describes as a brutal argument between the singer and his girlfriend Rihanna. Brown's arraignment was postponed until April 6th on charges of assault likely to cause great bodily injury and making criminal threats. He's out on $50,000 bail. My guest is Mike Kraut. He's a former prosecutor and deputy district attorney in Los Angeles. He's the managing attorney for the Kraut Law Group. Welcome back, Michael.
Thank you. Good morning.
Let's talk about some of the charges here and what they mean, what kind of time he could be facing, and then we'll move on from there.
All right. As currently filed, with no criminal background, as Mr. Brown has none, he's facing serious time on this one, these 2 counts. First, he has an assault likely to produce great bodily injury. The maximum is 4 years of state prison. And he's also facing criminal threats. The maximum is 3 years of state prison. The legal maneuvering that the California system allows would be a maximum of 5 years. You don't take the full second count. So it'd be 5 years in state prison. What's more consequential is that criminal threats is a strike offense in California, and assault likely to produce great bodily injury if there was a weapon used or if great bodily injury did occur is also a strike. Therefore, while the maximum he could serve on this count, in this case, would be 5 years state prison, if he picked up a future felony and was previously convicted of both of these as strikes, he could face 25 years to life under the California Penal Code system. Now, in reality, it's not expected that they will both be pled to or that it would go further, only because Rihanna appears to not be cooperating with law enforcement anymore and is now back together with Mr. Brown, and the relationship seems to be going back into a boyfriend-girlfriend role.
Before we get to that aspect of it, I want to talk about the delay in the arraignment. What does that mean?
Attorneys can ask for a delay in an arraignment, which is the point in which a client enters a plea of guilty or not guilty. As everybody knows, there was a tremendous amount of press and cameras at the arraignment scheduled yesterday for March 5th. It is a good strategy for an attorney to put the arraignment over. He put it over till April 6th. And what will now occur is there'll be discussions about what will happen. For Mr. Brown's sake, and because he's in entertainment, his brand is his name and his good image. And therefore, there is no way that they're going to allow a preliminary hearing to occur of which all these facts will be laid out, because the facts are being leaked and they're pretty horrendous. So what I would expect to occur is somewhere between now and April 6th, his attorneys and Mr. Brown and the district attorney's office will come to a plea arrangement, and the case will be advanced quickly and quietly without the press knowing, and there'll be a disposition and then a press conference afterwards.
Then let's talk about, should things go the other way, some things that might jeopardize the DA's case. Because there's a lot of odd things in this case. One, you've already mentioned, the fact that they are back together. 2, something that we talked about earlier, in that there's no restraining order here, which I guess is common in this type of case, which leads everybody to believe that they're trying to move forward and continue their relationship.
It's pro forma. The LA County District Attorney's Office, upon filing a domestic violence case or a case in which felonies or misdemeanors are being charged in a dating relationship, that a family protective order would be filed. In this case, Rihanna's attorney also went to court without Rihanna and asked the court not to issue that because they still were in a dating relationship. And the court granted that request and did not add one. You asked what might be a problem with the district attorney's case is that they're back together and she's not cooperative. They don't have testimony under oath that she has given that could be used in her absence if she failed to show. And that might weaken the district attorney's case. And that might be a reason why the LA County District Attorney's Office would also plea bargain with Mr. Brown.
What would be a typical plea bargain in this case?
Well, you'd look at a couple of things. You'd look at the age of the defendant. He's 19. You'd look at his criminal record. He has none. You'd look at his potential for success. He has great potential. You'd look at how whether he's been a civic leader and somebody who will give back to the community, and he appears to be someone like that. Then you look at the extent of the injuries. It's kind of a scale system, and the extent of the injuries and what he did was pretty dramatic. Then you'd also look at past conduct, and we're now finding out from Rihanna that his behavior is now escalating, and he's hit her in the past. So those things would counterbalance each other, and the district attorney's office would have to come to a resolution of whether there's going to be time, whether it's going to be maintained as a felony or will be pled down to a misdemeanor, or in the alternative, he could plead to a misdemeanor, to a felony, and then at a later point, it could be reduced to a misdemeanor and possibly expunged at a later point. And that's kind of the realm of what could occur.
Is there anything else that Rihanna does in this type of case to mitigate things, to actually help him?
Sure. Being by his side at all points is going to weaken the district attorney's case. It'll weaken the public outcry for what's happened, and it'll begin to diffuse the situation. If she fails to testify under subpoena, that will significantly weaken the district attorney's case. And as a former prosecutor, I can tell you that the LA County District Attorney's Office has a policy that if a witness is subpoenaed in any case except for a domestic violence case and they fail to show up, they can be locked up. In a domestic violence situation as this, they will not ask a court to lock up a witness until they're willing to testify. Therefore, she can't be compelled or forced to testify against him.
And ultimately, there's part of the plea would be some sort of intense counseling, I would imagine.
In all of these cases, the district attorney's office and the court independently would require a domestic battery and batterers program that's 52 weeks long, and it's 2 hours per week.
Appreciate your time, my guest, Mike Kraut, former prosecutor and deputy district attorney in Los Angeles. He is the managing attorney for the Kraut Law Group. Michael, thanks for your time today.
No problem. Thank you.
This is Scott Drake, and you're watching the Legal Broadcast Network. This is Scott Drake, and we know that as an attorney, you're very busy. That's why we have more content just like this at your fingertips, conveniently located at LegalBroadcastNetwork.com. Thanks for watching.